I'm told we can start now. We've got a fantastic panel ahead of us today, which was very kindly put together by the WomenEd Network. We will be discussing the growing interplay between data privacy and antitrust, which creates a great opportunity for further synergies, but also leaves a number of open questions on the potential for conflicting aims and objectives. This is a highly interesting issue and very timely given the Advocate General Ranter's opinion just yesterday. So great that we will have a full hour to discuss some of those issues. Now, quick introductions of the panel. Ana Sofia Rodriguez, Chief Economist and Head of the Bureau of Economic Studies and Market Monitoring at the Portuguese Competition Authority. Ana also holds a PhD in economics from the University of York and is the current president of the Association of Competition Economics. Karen Jelgerhuis-Wildens, a senior legal and competition counsel at Booking.com. Previously, Karen was a senior case handler at the Dutch Competition Authority, where she acted as the project leader of investigations, the digital procedure, and use of investigator powers, and was also active in the ECN. And finally, we have Teresa Basile, Privacy Director and Legal Counsel at Estée Lauder for the EMEA region, where she advises on EU privacy law and data security matters. Teresa is the founder of the WomenEd Privacy Network, and in addition to data privacy, she also has several years of experience in competition law. So I'm looking forward to a hugely interesting discussion about the interplay between data privacy and antitrust. For many years, those two regimes were viewed very much as separate and distinct. And this separatist view was originated or was reinforced by the Asnaf Equifax case, where the court famously rejected the intersection between competition law and data protection. However, as we all know, since then, the tech and data landscape has significantly changed, and the same is true for the regulatory instruments and antitrust enforcement, perhaps the best case in point being the German Facebook case. And I'm moving to you first. Is it right to say that privacy has now become a key or a very important aspect of antitrust enforcement? And more specifically, what role does privacy play in antitrust theories of harm and shaping competition law remedies?
No? Yes? Thank you, Monica, and thank you to WomenEd and to Lear for having me in this excellent panel. I'm delighted to join this discussion. Well, surely, as you say, the overlap in between data privacy and competition law enforcement, I think we can only expect it to expand as data-powered ecosystems become increasingly more ubiquitous and encompassing. So, and there are very many angles regarding data privacy and data-related competition concerns in assessments, both within mergers and antitrust, so both areas. And these various aspects and various angles may coexist within a given case, so they're not mutually exclusive. So maybe the most straightforward and direct one is to look at privacy as a dimension of quality or as an unpriced competition parameter, because surely consumers care about privacy. There's been a long-standing debate on this regard, on consumer valuation of privacy, and this has mainly followed some studies and some experiments that have uncovered a discrepancy in between, on the one hand, the declared preferences of consumers regarding privacy and how they evaluate privacy, and on the other hand, the revealed preferences on these dimensions that emerge from consumer behavior. Following those studies, there have been many hypotheses that have been put forward regarding this statistical finding or this empirical finding that relate, for example, with consumer behavioral biases, with lack of awareness of consumers as to the data that is being collected about them, or their ability to anticipate how these data could be used in the future. But regardless of where one stands in this debate regarding the privacy paradox, as it is called, I think it is fair to say that there is no doubt that consumers see privacy as a good. And thus, privacy is an important dimension of competition. So firms might compete with each other, for example, in terms of the development of privacy-enhancing technology. And for this to happen, there must be a combo driving these incentives that includes, on the one hand, the consumer preferences on privacy, and on the other hand, an essential element, which is the competitive discipline that provides firms with incentives for privacy-related innovation. So that is, I think, one of the most important aspects there. And you can have a theory of harm, for example, in a merger that may lead to the elimination of a long-standing policy of a firm to differentiate itself through privacy. And if this long-standing policy is reversed as a result of the merger, then you can have a reduction of consumer welfare by means of a reduction in privacy that is driven by a reduction in competition and a reduction in choice. Of course, the adherence of these theories of harm to a given case will depend, obviously, on whether in the market consumers perceive privacy policies as an important differentiation factor between firms. Now, another theory of harm that may emerge in merger cases has to do with a combination of data sets or data collection capabilities as an entry deterrence mechanism for firms aiming at protecting their ecosystem. The end game of these data-driven mergers may be to kill competition at entry points by restricting access by competitors, by rivals to data pooling or to data collection capabilities. And here I think one of the main challenges is to understand how data might be used and what purposes it may serve. And this might be particularly difficult for products that are yet to be developed or deployed. Now, another angle where competition and privacy are quite entangled relates to the firm's ability to extract consumer surplus. Having a realm of information and data on a consumer allows a firm to better nudge consumers in their choices, but also allows them to learn about their willingness to pay for products and services. That means that firms will may have a higher ability to extract consumer surplus. So whenever there are mergers that might result in the combination of data, it might be very important to assess whether the firm gains this ability to exploit consumers. So basically, if the merger takes the firm along a sliding scale of discrimination and whether this might hurt consumers. This is not just about price discrimination, but about several other ways of discrimination, such as price tiering. And here, I think that the use cases of data are very important. Certainly for users, it's very different if a firm uses data in order to distort these choices or to steer the consumer towards more expensive prices than other use cases for data, as for example, to help the consumer discover new music. So there's different use cases for data with very different implications in terms of consumer welfare. A note here, of course, that at the heart of these effects, there must be a competition issue so that these are dealt through either merger control or antitrust. These effects must play out through a reduction in competition that may play in terms of a reduction of choice, be it a static or a dynamic reduction of choice. A final note also in another type of theory of harm related with privacy to which competition enforcers need to be increasingly aware, that has to do with privacy washing as a cover for self-preferencing behavior. So these are some of the examples of theories of harm that relate with data and privacy. Now, in terms of remedies to address these types of concerns, these naturally will revolve around data portability and interoperability, depending on the type of concern that is at play. Now, and why is this so? Because at the core of competition in data-powered ecosystems is competition in users, which are akin to a data farm for digital platforms and ecosystems. Platforms rely on network effects to attract users and on switching costs to lock them in so that they can cash in on the rent from the data farm afterwards when they're protective from competitive discipline. And these incentives are very evident in the internal documents of Facebook that were disclosed by the FTC and the British Parliament regarding the Facebook WhatsApp acquisition. There, you can see that the internal communications reveal a story of incentives to kill competition at the entry points, but also one of consumer lock-in, as Facebook discusses imposing switching costs as a priority, a policy priority for Facebook, and is discussing how tough it is for a consumer to switch from Facebook if he cannot take content such as data, photos, or messages with them. So I think it is very important to think about this strategic consumer lock-in, and we need to bear in mind these strategies, especially when dealing with mergers that involve shifting control over large databases. And I think interoperability and data portability are key to prevent data network effects from being siloed within closed ecosystems, and it is key to empower consumers with choice so that they can be the drivers of the competitive discipline and that is what is going to deliver later on better outcomes in terms of privacy, because competition is at the core of every improvement for consumers, and privacy, I think, is no exception in that regard. Thank you.
Thank you very much, Anna. Data privacy is certainly evolving as one of the important parameters of competition, but I feel like we are still at the very beginning of this convergence, and a lot of tensions still remain to be resolved. Karen, turning to you, and from your industry perspective, what do you see as the main tensions between data privacy on the one hand and antitrust on the other? Do you think there is a way for these two regimes to coexist in a way that achieves good outcomes both for competition but also for consumers and innovation?
Thank you, Monica. So yes, well, just to run with the question, and we'll see where we land in terms of answers. Maybe I'll actually pose some more questions, as the title of the panel says as well. Managing expectations there. But I thought I'd just give you also, based on the theories of harm and the sort of overview that Anna-Sophia just gave, just talk a little bit about my perspective from a very practical point of view as being an in-house counsel, and what I observe in my role and based on my personal opinion. So when talking about Booking.com, yes, we are talking about the digital sector, about a technology company that collects and holds large amounts of data and personal data. But at the same time, I would actually also like everyone to keep in mind, and for this debate, that Booking.com operates in a two-sided transaction platform, ultimately thus creating a best match between a consumer and a business user of the platform. And also at the same time, looking at this platform where both sides of the users of the platform multi-home, there's evidence of this, and it means actually that they use comparable services for the service that Booking.com provides them with. So this relates to largely to accommodations, but also other travel verticals. So we actually look to offer a seamless experience between all these different services, and also using then combinations of data to actually improve the service to customers, and creating efficiencies by, for example, booking your accommodation and the taxi at the same time, which everyone who's been in the queue at the airport here will agree with that is a consumer benefit. And in order to give customers, with the data they provide us with, to give them a fitting travel advice, I'll just give you some of the ways that we use personal data and to actually do this. For example, the search ranking, which actually shows the most relevant options available on the platform. But at the same time, travelers can always choose a different sort order or filters that they find important to actually choose their best match or their accommodation of preference. So I think this also talks to your point as to or not a remedy, but in that setting. Another way that we have a lot of data, or that guests provide us a lot of data, is the reviews. We have over 200 million reviews that are authentic guest reviews who've actually stayed and paid at the accommodation to actually give a balanced impression of the accommodation that prospective guests will actually book. The same goes for any transportation options and experience. And to the side of the business users, they actually get a lot of data access to the information that that relates to that they're offering or their accommodation on the platform. And I have a range of analytical tools that will actually help increase the performance and competition between business users on the platform. So thinking about these use of this data, but also the then personal experience that a guest can have on the platform, and how to actually achieve on a day-to-day basis convergence and resolve any potential tensions, I think is very much in any products or service that you actually create, is to really closely align with in-house counsels from the privacy team, between the competition law, but also, not most importantly, also from a consumer law perspective. Doing this at the outset, for example, through risk assessments, whereby both interests are taken into account, and not as an afterthought, whereby a product or service is designed, and then at the very last minute, privacy concerns are taken into consideration. So I would say adhering to privacy principles as best practices, and indeed privacy by design, would look at resolve some of these tensions. And then thinking about whether the aims of competition law and data privacy, whether they actually are the same or divergent, even though they may not be the same, and the same goes for consumer law, because we see not just the two areas converging, but the third area as well, looking at the consumer interest from different angles. I think that from a platform perspective, you could actually look at what they have in common, and I think it's trust, and also the reputation of the company, of the platform long term, as opposed to, well, short-term gains or so I think from looking at that perspective, you may actually come to more convergence rather than tensions. However, so that's from the internal perspective on alignment, and I think, well, from a regulator perspective, you would actually look to actually see that alignment mirrored. However, what we've seen in practice, and also working for a global platform, but equally across Europe, having dealt with competition law issues like parity, or consumer law issues like transparency requirements on, for example, the ranking or on any other messaging, you can actually see that even though, well, we've done our best to actually get alignment across, well, at EU level, there are, even though either the legal framework from a consumer law perspective, for example, allows more stringent measures. However, from a competition law perspective, that remains to be seen. There are diverging outcomes across Europe, and this is, well, a challenge for competition law and consumer law in isolation. But I see some challenges ahead when it comes to the convergence of these areas and how to actually achieve alignment there. Then to finish up, do I see just convergence and alignment and all positive aspects and just believing in the overarching trust and reputation? I do think that, for example, there will be, as we're at the start, there will be at times that there will be tension, and maybe from a user perspective, adhering to too stringent data privacy from that perspective may not be the best experience. And yeah, I'll look forward to how this develops.
Thank you so much. It was actually more encouraging and positive than I was expecting. So this is good news. So Anna-Sophia and Karen shared some great views about the current tensions and issues that we are seeing with respect to existing technologies, but Teresa will take us on a journey into the future, to the next big thing, the metaverse. So Teresa, what do you think are the main privacy and antitrust issues that we should be looking out for as metaverse develops and matures?
Thank you so much, Monica, and thank you for inviting me. So I will bring you on the metaverse dimension, this parallel and virtual universe where physical and digital meet. As you may know, metaverse is fueled by many different types of technologies which are developing and progressing while we talk, like the virtual reality, the augmented reality, the artificial intelligence, the blockchain, the non-fungible tokens, which are digital assets whose value is given by their unicity and scarcity. But metaverse has a value, and there is an interesting report which was released very recently by McKinsey on the value creation of the metaverse. The economic value of the metaverse, I'm just reading, the study suggests that it may generate up to $5 trillion by 2030, equivalent to the size of the world's third largest economy, Japan. In terms of consumer perception, this study is particularly relevant because it says that 60% of consumers, being part of this survey, are excited about the transition of everyday activities to metaverse, to the metaverse dimension, and about 79% of consumers active on the metaverse have made a purchase. I can now tell you about my company's experience on the metaverse. We are approaching the metaverse via some promotional campaigns, leveraging the non-fungible tokens. Very recently this summer, during the Metaverse Fashion Week, because there was a Metaverse Fashion Week, we teamed up with a Metaverse artist and created a non-fungible token for avatars so that users of the Metaverse who were able to find a bottle of our flagship product in the Metaverse and enter inside the bottle could claim their certificate of attendance protocol and request their non-fungible token, which gave those avatars, their avatars, a radiant look. Those non-fungible tokens were released for free and in a limited number of copies. Now, from a privacy perspective, as we know, metaverse is extremely positive, but there are risks from a privacy perspective because of the potential accumulation of an increasing number of personal data. So we have the instrument, GDPR gives us the instrument to mitigate and address risks on the metaverse dimension. First of all, we need to minimize, and this is my advice every day, minimize the collection of the personal information, of the personal data as much as we can. The privacy by design, as we discussed before, is the key, but also the data protection impact assessment in advance of the launch of every project involving or impacting the metaverse dimension. transparency, full transparency. Users of the metaverse and their avatars must be able to understand why we are collecting the data and the purpose for which we are collecting data. If there is any deviation from this original purpose, you need to request a consent. But what is the challenge from a privacy perspective? It's mainly, especially because there are decentralized platforms, to understand in advance who is the controller. In my personal opinion, this is the most tricky one. It's not always the case that you have just one controller, and on a case-by-case basis, you need to define and assess, because with the controller comes the responsibility of respecting the privacy rights of the users and making sure that those privacy rights can be enforced properly and effectively. There is then the aspect of the InfoSec, the info security, and indeed, it's not, technically speaking, a privacy element, but we team up with our InfoSec teams to make sure that we can address both cybersecurity and security linked, for instance, to the use of those wallets in the metaverse dimension. And now I would like to just mention antitrust and competition. And I believe the DMA will be potentially a good instrument to address the risks from an antitrust competition perspective in the metaverse, both in terms of interoperability and in terms of strong contestability of those who will be the potential gatekeepers in the metaverse dimension. One other element I would like to mention is the draft artificial intelligence regulation. This instrument will be also helpful to address the aspect of collection of biometric data, which are those data related to the physical, physiological, and behavioral characteristics of the individuals, and which do uniquely identify the individuals, which may be subject to collection in the metaverse. So I believe the instruments are there to address and mitigate the risk. Metaverse is here to stay, is promising, but I think we all together, we need to make it responsible, ethical, and sustainable. Thank you.
Thank you very much. I will hold us in the future in this brave new world for a little bit longer. It feels like at the time when regulators are finally coming to grips with technologies such as social media, e-commerce, ad tech, there are already new things appearing on the horizon. Indeed, industries have already started moving to such technologies as Metaverse, which Teresa mentioned, crypto, quantum technology, and so on. And I have two questions on that. The first one, which Teresa already partly answered, but I'll give a chance to Anna-Sophia as well and Karen. What do you see as the next new big thing, the next disruptor that regulators will need to closely observe and react to? And the second question, which is a bit more general, is what steps more generally the agencies should be taking in order to preempt any new issues, but in a way that doesn't inhibit innovation and still creates a good regulatory landscape for innovation to thrive. I would like to invite each of you to offer quick views. Shall we start with Karen and move in this direction?
Sure. My view of the future didn't reach as far as actually looking at the present and the challenges that we face and I think the agencies face. And indeed, we're just at the beginning. But what I actually do see, whether it's indeed the metaverse, any new technology, or still any algorithms or business models, I would encourage authorities, and I see this from personal experience and having, doing a tour de l'Europe and seeing different agencies, will give you that insight, or even beyond Europe, is how, when I talked about ranking, for example, how, explaining algorithms, or to mostly either lawyers or economists, and understanding what it actually, how the technology works. Not just when there's an investigation or when you actually need to call a company for any answers, but in finding different ways of engaging with businesses and setting up a dialogue that will also allow businesses to open up without any, well, direct disincentives of any enforcement or fearing any investigations by disclosing more information that than they would normally do mainly. So I think really focus on, yeah, regardless of what is new and shiny, really sort of, and focus on the business models, focus on the use cases. I've sort of gave some examples of how our platform operates. Really look at what is at hand and what are the use cases, where the concerns from privacy and potential competition perspective arise.
Well, I'm going to free ride on the ideas of both Teresa and Karen. Indeed, it's difficult to pinpoint something else other than Metaverse and the Internet of Things as the new, the key technological developments for the years to come. The Internet of Things is all around us already, so Metaverse is still something that is longer way ahead, although the foundations of it are being built today. Now, in terms of a competition policy perspective, and here bringing a view of an enforcer, I believe that there's a real possibility that these developments will represent a major technological paradigm shift. They will interplay with each other, and this will have a big impact in terms of the landscape. And as new products and as new business models will arise with these potential technological paradigm shifts, I think there's also opportunities for contestability, opportunities for shaking the established landscape in the digital sphere. Now, I think that as the Metaverse and the Internet of Things will emerge, there will be new entry points to the ecosystem. So I think the main concern from a competition policy or a more broader regulatory perspective is ensuring that these new entry points function well, that they're not blocked by either mergers or anti-competitive conduct by established digital incumbents that currently have gatekeepers' position. And there have been concerns that have been voiced to this regard, concerns that the established incumbents may muscle their market power and their existing gatekeeper positions to the Metaverse sphere so that they can gain a foothold in those new markets. So I think that is, from a competition policy perspective, the main challenge will be to make sure that we reap the benefits of the windows of opportunity for contestability that will emerge here. And there have been several developments on this regard. We know that there's been at least 2 recent cases, one by the Bundeskartellamt regarding these issues, and this had to do with proceedings against Facebook for requiring users of the Oculus VR headsets to have a Facebook account. So the concerns again here are linked to the potential attempt by Facebook to translate its current position to the virtual reality to VR markets. But also in the US, as we know, that the FTC has filed a suit against Facebook acquisition of a VR fitness app. Again, here concerns related with risks of decreased consumer choice, innovation, and reduced competitive pressure. Vice President Vestager has already signaled that the future operation of the Metaverse should face more scrutiny, and that the creation of these all-encompassing virtual reality environments will pose new challenges for antitrust regulators. But I think that at the heart of the solutions, again, Interoperability and data portability will be essential in the metaverse if we are going to take advantage of this window of opportunity to introduce contestability in these markets. I think it is key to avoid both consumer and developer lock-in and increasing choice and innovation in these new realities. And I think these are similar conclusions to those that we have reached in existing digital markets. So I tend to conclude that likely this is going to be old wine in very new, very sophisticating and dazzling bottles.
Thank you. I will just to add one point. I mean, in terms of new technologies and trends, yes, the metaverse and all the technologies surrounding the metaverse, including the non-fungible tokens. But in my view, it's important that authorities work in tandem and grasp the essence of those technologies. And this can be done also by including the community of users, business users and users. Now, the DMA already refers to this high-level advisory group, which is a good thing. And in the past, since 2006, we had the Digital Clearinghouse, which is a platform putting together the data protection authorities, the competition and consumer authorities. Again, this should be expanded, enlarged to the users, business and end users, to make sure that we are all on the same page, starting from the definition of what is metaverse, what is non-fungible token, and all the relevant technologies. Thank you.
Thank you. Mm-hmm.
I said I was going to free ride on Teresa and Karen, and I forgot to mention on algorithms very quickly, very briefly, because I think that is a very important point. And as we discuss technological developments, we get very impressed by these new technologies. But I think that we must continue to keep an eye on algorithms. One of the main issues at the Portuguese Competition Authority that we have been concerned with and trying to assess is the ability of, or the risk of competition, for competition and collusion that algorithms may bring about. And here I think the challenge is, and this might happen as we move along, that you can imagine algorithms and algorithm developers producing price algorithms for firms. They do it already today. You can imagine sectors delegating jointly their pricing decision to algorithm developers. And the challenges to understand this, I think, are still very important. And one of the things that we have been faced with as we try to make a survey to algorithm developers to understand which sectors of the Portuguese economy they were serving, because obviously the concerns are going to be much more important if you're speaking about an oligopoly with high barriers to entry than a very competitive market with no barriers to entry. And what we felt there is obviously the algorithm developers very often are not based in the jurisdiction in which you are. And we had to send requests for information to firms that are based in China or the US or in the UK or in many other geographies. And there we were faced with the limits of jurisdiction, and we found that it was very challenging to be able to map all of these issues regarding Portugal, where we have jurisdiction, and we felt that this is something at least that where cooperation needs to be strengthened in order to allow us to grasp the full implications of algorithms.
So this is very interesting. One follow-up question on that. So were you, by cooperation, do you mean cooperation between competition authorities or privacy authorities as well to allow you access to? Well, with
competition authorities and more broadly competition-related entities.
Consumer protection bodies.
Yeah.
Mm-hmm. Super interesting. So just one final question from me before we move to the audience, and this final question will relate to the DMA, the elephant in the room. So the text of the DMA specifically states that the DMA will apply without prejudice to other legislative instruments such as the GDPR, competition rules, and consumer protection rules. And focusing specifically on this interplay between the DMA and GDPR, how, in your view, the DMA's data sharing obligations will coexist with the GDPR? And more generally, what steps should be taken to clarify this interplay between the DMA and data protection rules? Karen, shall we start with you again?
Yes, thanks, Monica. So indeed, stating on one hand in one act, obviously the Digital Markets Act, stating that whatever you do is without prejudice, entering someone's territory or sort of converging into the other territory, saying, oh, those will still exist without prejudice. I think also in some articles, there's already indeed, as you mentioned, there are some questions of how the interplay between both laws will actually take shape. Again, how this will, of course, with certain business models in mind, the DMA has been drafted. Does that also apply to other business models? How will this actually work in practice? I think there's a lot of questions to be answered, whether indeed what is stated will actually get the best outcome for consumers and also from an innovation perspective, whether those clauses and those obligations will give that desired effect. Again, I think have a more formalized cooperation, and Teresa also mentioned examples of across the industry of all stakeholders, but equally, and also as I mentioned, across Europe with national authorities of the different disciplines. I think only with everyone at the table you can actually say, "Oops, I'm not overstepping the mark," or it's fine. So that would be my recommendation.
Well, the DMA and the GDPR interplay. I think, obviously, all the data portability and interoperability on personal data, the obligations that related to that at the DMA, they're all subject to the consent by the consumer. So, as the DMA can be seen as strengthening further the GDPR and going beyond it to some extent. But what I think it's important to highlight, and I'm speaking, of course, as a competition policy enforcer, and I'm giving my take on that, what's important to highlight is that at the root of these two regimes are two very different concerns. While both of them seek to empower consumers, on the GDPR, the concern is on ensuring control of data by consumers, and the backbone of the DMA is quite a different one, is one that is focused on contestability, on promoting competition, which can then deliver option, including in terms of privacy for consumers. And this is done by facilitating switching and multi-homing. So these are two very different takes. Now, in terms of, and again, as a competition policy enforcer, in terms of how these will interplay, and more importantly, how they will be implemented and how the DMA, the portability obligations will be implemented, I think we face challenges ahead. We face challenges because going from law, from regulation to practice in this type of markets can be challenging. And we can take an example of the challenges that may emerge from an experience that is already out there that concerns the fintech and the Second Payment Directive, which already envisages provisions for data access and data portability within payment systems. And there, in spite of the regulation that has been transposed into the EU, the directive that has been transposed into EU member states and has been implemented, there were regulatory technical standards that have been developed to implement these regulations. The challenges have to do with the risk that incumbents may try to thwart the efficacy of these measures. They might try to do it, for example, by creating hurdles in the process of user consent. As we know, inconvenience in itself for consumers may be enough to foreclose a rival or a potential entrant. So one of the key concerns that I think must be there in order to pursue effectively the DMA objectives is to ensure that all these processes happen in a seamless way, so as to reduce the risk that we fall short from fully implementing data portability and data interoperability. And I think this would be the main issues. Now, on this regard, at the Portuguese Competition Authority last year, we published a report of a survey that we did to fintech operators. This survey was done precisely to assess which barriers to entry remained regarding data access after the implementation of PSD2. And when we got the replies, you could see many different issues being put forward, such as the delay in response times to API access requirements, additional security or consent requirements that are introduced other than those that are mandated by law, high error rates when connecting with APIs, delays in the implementation of APIs. So in terms of technological implementation of these things, I think there are many challenges ahead. We must learn the lessons from this PSD2 implementation, and surely this will be no walk in the park, but by trying to reduce degrees of freedom of incumbents as they need to fulfill these obligations, both from the GDPR and the DMA, I think it's very important.
Thank you. From my perspective, the DMA already sets some sort of clear boundaries between the application of the same DMA and GDPR. Any consent gathering exercise is clear for an advertising purpose or for a profiling purpose is clear in the DMA that it is under the realm of the GDPR and the enforcement of the data protection authorities. In terms of portability rights, the DMA mentions the portability, but the portability is somewhat complementing the concept we have already in the GDPR, meaning that in the DMA, portability includes aggregated data, which by default under the GDPR are non-personal data, are anonymized data, while if the portability refers to personal data, then you have the GDPR, which applies. So I believe there are already some sort of indications or where the DMA starts and ends and when the GDPR enters into play. One other element, if I remember well, there is an obligation for the gatekeepers to provide a report, an audited report of profiling activities, which must also indicate the compliance with GDPR. Those reports must be sent by the DG Comp or DG Connect, the relevant commission authority, to the European Data Protection Board. So what we need is just to make sure that in the further implementation, the guidelines for the implementation of the DMA clarify all those boundaries with practical examples. And again, we need the cooperation, the public consultations, and the cooperations of all stakeholders, business and end users. Thank you.
Thank you, so fantastic. Thank you so much. We have a few minutes left, so we can open the floor for the questions from the audience. If anyone has a question, I think here's one. Shall we take the gentleman here? Yeah.
Thank you. Asser Hansen from Merger Filers. I have a question about, I think, what you started on, Anna, in the session, about data protection being sort of a quality that companies or businesses should compete within. My question is isn't it actually an area that actually calls for standardization? To me, when I look at data policies from a provider, that's something that I don't want to get into. It's just pages that you just accept it. I don't read how these policies differ from a competitor. So for me, I think this is an area where standardization would be called for?
Standardization is a word that, for competition policy enforcers, I think standardization that is introduced by regulation is probably something that can have a lot of benefits. However, what I was referring to, I think, is more privacy enhancing technologies is a world of opportunities in terms of the improvements that firms can integrate into their products by design, as Karen was mentioning earlier on, to be able to attract more users, particularly if consumers are able to grasp these functionalities well. Obviously, all the competitive interplay means that there's a leapfrog, there's an incentive to overtake a rival in terms of the functionalities for any quality dimension that the rival might offer, and I think privacy is no exception to that respect. There are, of course, some issues regarding data privacy that have to do with regulation that naturally introduce some standardization. But generally speaking, or more broadly, I think that the competitive process means that each firm will try to gain consumers by differentiating its product and offering a higher value for consumers, including regarding privacy protection, I believe.
Thank you so much. There's one more question here. I think we have still 4 minutes left.
Thank you. My name is Liliana Eskenazi. I had a question about cooperation between authorities. You mentioned that, well, there is a high-level group that was set up by the DMA, and you mentioned that there could be cooperation between regulators like Competition Authority and privacy regulators, and it's a good thing indeed, because when we read the directions we receive from the Court of Justice or the upcoming, we saw the opinion yesterday that shows that Competition Authority might be able to apply other sets of rules, and there's quite a lot of overlap with the DMA as well. It's definitely a good thing that competition authorities and other regulators can cooperate to come up with a common vision on the basic concepts. But my question is how far that cooperation should go, and isn't there a risk that while talking about topics or even going further, cooperating in investigations, like the DMA gives the possibility for national competition authorities to start investigations and then report to the Commission facts and elements that would allow to start an investigation under the DMA, which is a different set of rules. How can we reconcile this, and how can we ensure that companies will have their procedural, even defense rights respected in these cases when there is basically a lot of exchange of information going on between authorities and possibilities to start investigations on one legal basis and transferring it to another one, and possibly parallel investigations and ultimately sanctions for companies? Thank you.
Anna-Sophia, would you like to start?
Yeah, well, cooperation between competition authorities is there, of course, within the ECN, within the ICN. I'm probably not, I'm always actually never very precise on the terms, but the cooperation between the ECN, the exchange of information, that is all set up in the treaties and on you know, all those legal documents that you probably know better than I do regarding cooperation instruments. So I think they're very important, and in implementation of the DMA, not only on the drafting of the DMA, that of course there was a lot of exchange and cooperation on that regard, but also on the implementation of the DMA, the cooperation will be key. Will be key on two aspects, I think. One is because the DMA does not prevent or preclude competition enforcement and antitrust. There are several issues that will remain there, and not only when the scope is more national, but also there are issues. At Portugal, we have opened 2 investigations this year that include issues of competition in digital markets that are not covered by the DMA. So there will be complementarity in between antitrust enforcement and DMA implementation. And then, as you well noted, the DMA implementation will be centralized at the European Commission, and there's obvious reasons for that and benefits that accrue from that. But national competition authorities will be assisting whenever needed and whenever called upon the Commission in the implementation of the obligations that are set forth in the DMA. And I think this is very good news. This is very good news, I think, because this will allow the Commission to have also resources at the national level to be able to get a grasp of the national issues at stake and the specificities at the national level. So I think this is very good news. Then again, what I think cooperation might be more important, or where is maybe lacking more, is at an international level. There we have a lot of cooperation in terms of exchange, but there's much more limitations than the framework that applies within the ECN. And that, I think, it's something that, we could benefit from further enhancement of cooperation.
Fantastic. Thank you so much. Teresa, Karen, any final views on this question?
Just echoing what Anna said, but also considering the other element of, apart from the legal certainty, also the fact that we need to avoid any potential fragmentation of the internal market. And I think cooperation must be effective also to avoid this type of fragmentation, not only from the data competition authorities side, but also from the data protection authorities side.
Karen?
I could not agree more.
Brilliant, and we are almost within time. I just wanted to, and so actually a perfect segue to the next panel, which will focus on the interplay between DMA and national competition rules. So it's a good move to the next session. I just wanted to offer a big thanks to all 3 panelists. It's been a fantastic discussion, and the one that will definitely continue. So big thank you to 3 of you. Thank you very much.